Yes, very good. Thank you so much. And welcome everybody. I can see the amount of participants are increasing as we go. So before we get to the subject matter, um, I think I would just mention that my name is Ola Linder, and I'm going to take you through this webinar as we go as your moderator. And we have a very interesting topic on the agenda today, and we have many very interesting speakers, and I'm really looking forward to hear what you all have to say. Before we go to the speakers, Ines, please, would you explain some of the technicalities of this webinar?
Yes, I will do so, Ola. Thank you. Welcome as well from Ines part to the webinar. So for those of you who haven't used the Zoom platform before, all the attendees will be on mute during the webinar. If you would like to ask a question at any point during the webinar, please use the question and answer box, which you should see on your screens, and type in your questions. You can type in your question at any time, and we will monitor the question box and pass on the questions to the speakers. You can also use the chat box either to ask a question or in case you have trouble following or hearing, please do so, or you can use the email drdn@independentliving.org during or after the webinar to contact us. One of the speakers will have not simultaneous, consecutive translation, interpretation from Spanish. Just so you know to expect that. And I think this is about it for the technicalities. Yes, please note we are recording the webinar, and the recording will be available after on our websites and on YouTube. You will also receive a short report and the PowerPoint slides. So don't worry if you don't manage to take notes, or if there are any links to reports, etc. These will all be available to you, and you can always contact us with additional questions or clarifications. And I think Ola will explain when we will be taking questions. We'll have a moderated discussion after the presentations, right? So, but feel free to ask questions even during presentations. I think that's it from me. Ola, I will hand over to you again.
Yes, thank you very much for this. In these times, we increasingly get comfortable with using these different digital platforms. And I'm very happy to see that we are organizing this together, different actors, and we have many interesting speakers as well. Behind this seminar is formally the European Network of Independent Living, the Disability Rights Defenders Network, which is a part of the Independent Living Institute based in Sweden, although we work with international matters quite a lot in international human rights law, increasingly. So to go to the agenda, thank you. We have several speakers. I was asked to introduce very briefly the topic of law clinics and how we can think about these issues on a general level regarding disability rights and access to justice. But before we do that, I should say that we're going towards perhaps half of this seminar, maybe in about an hour or so, take a short break for accessibility. I'm going to mention pretty much everything that's on all of the slides so that we don't miss anything. I've heard that the screen readers are not so good with reading what's on the actual slides. So on this slide, we have here the agenda. We have the welcome and opening and technical instructions by Ines Bulic from the European Network of Independent Living. I will introduce the topic of law clinics and the agenda. After that, we have a talk by Michael Stein, the co-founder and executive director of the Harvard Law School Project on Disability and visiting professor at Harvard Law School in the United States of America, on the role of academics in disability rights advocacy. Then we have Anna Bruce, teacher and researcher at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden, on the topic of starting the Lund Disability Human Rights Clinic, which is a cooperation between academia and some non-governmental organizations of persons with disabilities, or DPOs, Disabled People's Organizations. And we're very happy to say from Ely that we're one of them working together with you. Next slide, please. To move on the agenda, we have Jose Martocci, Director of the Legal Clinic on Human Rights at the National University in Argentina, which is going to be translated into English by Mariella Gagliazzi on the topic of legal clinics on human rights and disability rights, and especially on the experience of collective litigation in Argentina. Next up, we have Juan Cobeñas, who is a disability rights activist and user of alternative augmentative communication, also from Argentina, on the topic of the reporting involvement and experience in a case supported by the legal clinic there. Towards the end of this, we will have a moderated discussion. And if you have any questions on something you want to have clarified by any of the speakers, or something very directly on the topic there, you can always ask them then. But please remember also that we do have a longer discussion towards the end of this. I'm thinking that we should take the break if we go back to the previous slide, perhaps after Anna's talk. You all will have roughly 15 minutes to give your talks. I have been instructed to use some of these figures. So we have a 5-minute mark and a 1-minute mark. Those who use interpreters will be given some additional time, so you don't have to feel stressed about having the interpretation as something that slows your message down or something, given the time frames. I think that's pretty much it. So before we go on to the speakers, I should say that law clinics are not a very established phenomenon in Sweden. I've been personally interested in them because when I went to law school, we had something on online hate speech, which was new at our university entirely. So I started to become interested in seeing how we could work with these things. I never really did until recently, and that's why I'm very happy to see that we at Independent Living Institute, and especially our project on Article 19 of the UN Convention on the Rights of Persons with Disabilities, that focuses on the right to live independently in the community, very much focused on self-determination for disabled people, has been able to match up with the Raoul Wallenberg Institute to increase our capacity as a small NGO to have access to legal researchers that are working with a human rights perspective, because that's really something that's lacking. We have many people come to our NGO, and sometimes we can't really offer them the full support that they need because of our limited resources. So it's a very good way to, I think, connect the engagement of students who are learning and who want to have a more practical experience with the need of civil society. More on that later. So to go back to the agenda then, to move on. We have Michael Stein, welcome, and I give the floor to you.
Well, thank you ever so much. I'm very happy to join you. I will preface it by saying that you've asked me to talk about litigation and legal clinics, and I'm happy to. But first, it's been 16 years since we founded the Harvard Law School Project on Disability. Most of our work is not on formal litigation. I would say it's perhaps about 5% of the docket of what we do in our typical 80-hour weeks. But we are involved. Some things that mostly what we do is actually work with civil society on trying to advocate for change under the CRPD. And we've done that in 40-something countries. I've been in over 40 on the ground. But you want to talk about litigation, so let's speak about that. One thing we do on the perimeters of litigation is that because there are so few law school clinics and insufficient number of public interest firms focused on disability rights, although far more than in Europe or Latin America or other places. Just as a regular courtesy, every week I think I probably receive 2 to 4 emails asking me to refer them to lawyers or to represent them, which I don't do. I have not been in a courtroom and to litigate a case in perhaps 25 years. But what we do is we will intervene in cases, usually at the European Court of Human Rights or at Supreme Courts or constitutional courts at the highest national levels. And there we try to be of use in defining disability issues and at times trying to coordinate some of the issues going forward. So examples of that would include, we've intervened in something along the lines of 21 or 22 European Court of Human Rights cases. Most of these cases were previously brought by public interest firms. A good many of them were brought by MDAC before it became Validity, and specifically by János Fiala, who was my friend, still is my friend, then became my LLM student, my SJD student, still is my friend, is now teaching at Galway and working with their clinic. So many of these cases were brought on behalf of individuals with psychosocial disabilities, a range of issues from involuntary institutionalization to other issues. And when we intervened, János was already with me at Harvard, and we intervened post-CRPD to try to interject to the European Court what the CRPD would say or might say about these specific issues. And we tried to keep a very narrow approach. Of course, with the European Court, one is not supposed to argue the facts. One is supposed to speak in a vacuum and simply provide guidance. But of course, one frames one's arguments in such a way that makes it helpful for the court to try to resolve the case at bar. Part of our strategy is also to try to frame the arguments that we make in such a way that the court can use it in other instances beyond the case in front of it. So a typical example would be the Kish case against Hungary, which involved the following fact scenario. Everyone in Hungary with a disability gets put under guardianship. Anyone under guardianship is not allowed to vote. Therefore, people with disabilities not allowed to vote in Hungary. When writing to the court, both in asking permission to intervene and also in writing our brief, we tried to make arguments overtly and stated so to the court that these are arguments that can be used in a multitude of countries and circumstances rather than have the court have to reinvent the wheel and re-examine things time after time. And if you read the case, you'll see that, one, they acknowledge us, which is very nice. But two, they also lifted out portions of the brief and used it in their opinion. And that's exactly the best case scenario. Doesn't happen every time, but it's the best case scenario and what you would like to happen. We did the same thing with the CRBD committee. We brought the first intervention before them. We required the committee to change the rules of procedure in order to allow a third-party intervention. And there we also had the ability, because of being among the disability community and knowing the members of the committee and so on without identifying them, we were able to communicate informally with them and say, look, since we're bringing this on voting and persons with intellectual disabilities, will write it in such a way that you can use parts of the brief in your jurisprudence, and they did the same thing. At times, our goal is to try to collaborate and to try to moderate some of what other interveners might be doing. So a classical case would be in front of the Inter-American Commission, the Chinchilla case from Guatemala. The facts are that it was a woman put into prison for multiple criminal activities. She had diabetes, her leg was amputated. She wound up using a wheelchair in an inaccessible environment and eventually died because she fell down the stairs in her wheelchair. Many of the OSI-based clinics intervened. It's a Spanish language case. It's highly appropriate for the Inter-American Commission. It's really their bread and butter. But they all wanted to take different approaches to the case. we were unsuccessful in trying to get the clinics to all join together in one brief. The idea being that you have clinics from different Latin American countries all coming together, all having one voice and making the argument we thought would be convincing to the Inter-American Commission. It didn't work that way. And instead they focused on different issues ranging from cruel and unusual punishment to lack of freedom and liberty of movement, to reparations. We instead took a very simple approach, which was we wanted the court, to come away with one thing, and that is to say, individuals with disabilities under state care and in their responsibility, meaning jails, educational institutions, God forbid, institutions of congregate care, which we hope will disappear but have not yet done so, have a duty to reasonably accommodate those individuals and to care for them. That was the one line we wanted to come out of the decision. And the court sort of hints at it, but doesn't really go that way. So sometimes our goal is to try to coordinate, and mostly our goal is to try to come away with one line. There was a case in the European Court of Human Rights called Friedlova, which involved a woman being raped in an institution under care and the institution failing to investigate. That case wound up being settled because MDAC's subsequent staff, it was under Oliver Lewis, wound up settling the case on behalf of Friedlova and obtained a judgment, which I'm not God, what can I say? I hope it gave her some comfort because she died of cancer about 2 weeks afterwards. But the goal of us in our intervention in that case was to try to draw a linkage between the European Convention's duty to investigate torture and abuse and the CRPD, and to say that that duty would exist under the CRPD. So sometimes we're trying to make linkages between different treaties and between different forms of jurisprudence. Sometimes our interventions are without being named explicitly. So the South African case, Western Cape, which involved the exclusion of all children with severe to profound intellectual disabilities, their use of the term, not mine, from any schooling in violation of the CRPD, in violation of the CRC, in violation of the South African Constitution, in violation of any kind of decency or norm. In that case, I was active in helping to draft some of the pleadings and some of the briefs, but without attribution. My name doesn't appear on the brief, and that's just fine. I'm happy to do that. Other cases that are, to be honest, not of great priority to me, but which I become involved in of necessity over the last 3 years, has been increasingly suing or joining in suits against the Trump administration just because they're so awful. And that range from the Muslim travel bans for the very personal reason of being the child of immigrants and being profoundly affected and angered by it, to the whole range of asylum cases where the Trump administration has taken away the right to counsel of people with psychosocial disabilities, has encouraged the referees to interpret the law so that one has to argue that Mexico, which is often the defendant state, intended to torture individuals by using ECT or isolation, rather than simply torturing them because of what they did. They had to have an intent to do it. We've become more involved in that as well. Sometimes my role is to shift potential cases to other law clinics. So at Harvard, we have about 16 or so human rights clinics ranging in different subject matters, from disabled veterans benefits to housing to educational law. And I try as much as I can to link with them and to bring them into these cases where we can't handle it ourselves. Sometimes my role is also to try to instigate litigation, and since we're being recorded, I won't name names specifically, but that South African case I mentioned, it was brought by the Legal Resources Center, one of the oldest and best public interest firms. Legal Resources Center had done nothing, literally nothing on disability despite their charter including disability, despite their funding mandating that they include disability, they had done zero on disability. And once on a visit to, to their office in Cape Town, I went to meet with their board of directors. I was carried up the stairs in my wheelchair. I met with their board of directors who explained the reason they didn't do disability cases was that people with disabilities didn't come in requesting help. And I said, well, not everyone was stupid enough to be carried up the stairs as I was. And they talked about how they were overextended, overwhelmed, as we all are. And finally, I had to say to them that I had spoken to two of the board members of their funding mandate. They're funded through a foundation, and that I had authority to share with them if they were unwilling to do disability work as was required by their mandate, those individuals would vote against their full funding in accordance with them receiving instead a prorated portion of their funding. That's where that case initiated. So sometimes I'm there to initiate by pressing or cajoling, asking nicely, if not trying to put pressure to bear on individuals. So a broad range of cases that work that way. And I guess I should mention that in the US, sometimes I'm also on briefs or working on briefs, but without attribution. So perhaps the best known of that was the Happy Trust, which had to do with Google digitizing all these materials for state libraries and the copyright holders arguing that they ought not to. So it's a privilege. It's something that I think we are going to turn to with greater frequency, especially with having some of my personnel returning to work with us this year, and students interested in brief writing and contributions. And I think that's probably where I'll stop. So thank you for having me, and I very much look forward to hearing my fellow colleagues and their interventions.
Thank you so much, Michael. That was very illuminating and interesting to hear about how you work in your clinic, including with litigation. Can I ask you something before we move on to the next speaker? You mentioned that you work with negotiation or that you approach different potential respondents without actually litigating. Can you explain something about how you do that, or how many of the cases don't you litigate, or what strategies do you use?
I have not litigated a case, meaning go before a judge or a jury, in 25 years. I am in touch. I wish I was in greater touch with the global disability rights community. Somewhere watching is our friend Jukka from Finland. And so I receive information and invitations, and we try to intervene where appropriate once they're standing, once admissibility has been passed, when we can make a use and when we can make a contribution. Some courts and jurisdictions have made it more difficult. The CRPD committee, with the posting of the types of cases that they have, but then requiring, much like some of the other treaty bodies, that you write in and say, gosh, I'd like to be involved in this independent living case against the government of Paraguay, but not knowing any of the facts unless you happen to know the litigants. And then the secretariat of the committee will pass it on to both the state, which of course won't want me involved, and the litigant who may or may not want me involved. That makes it difficult. The procedural rules at the European Court of Justice, whose Chief Justice is a Harvard alum and a lovely individual, and has said, I wish we had disability cases. And I said, I wish you did too, because they can only take cases that are referred to them by the highest level national courts, have not had any on their docket. So in some cases, you're really restricted by what the procedural rules are and by what the access to information rules are. And they're not particularly more difficult in the case of disability, but it does make it less than transparent for good reasons of privacy and some other reasons that perhaps are not as good.
It's very interesting to hear that you were a part of the case in Hungary. I'm not sure if I pronounce it right, but the Alias Kiss case. concerning the right to vote for people with intellectual disabilities. I know that there is a pending case from Denmark as we speak concerning very similar circumstances. I really hope that they will come to a similar conclusion as in that case, because the court found that having a pretty much blanket ban on the right to vote in the national elections for people with certain intellectual disabilities was in violation of the right to vote under the protocols under the convention, which is almost self-evident. But many countries do have this practice, and since the countries do enjoy a certain margin of appreciation, it was a very finely litigated case to have that outcome in the end after all. So I'm hoping that they will use that case in the pending case now concerning Denmark. And it is true that they had to go through the highest courts and fail there before they can go to the European Court of Human Rights. So I know that they had a long fight in Denmark before they could go there. So thank you. I think we should move on to the next speaker, and I welcome Anna Bruce.
There. Hello, everyone. I'm very happy to be here virtually, as we all are. So my presentation will be talking about a very new disability rights legal clinic. Indeed, we're just about to complete the first session, so the first batch of students are just finishing. So I will share with you the journey that has been this far, what we've learned, and a little about what we hope for the future. And I've titled my presentation Starting the Lund Human Rights Clinic, cooperation between academia and NGOs of persons with disabilities, or DPOs. And so the two focus of the presentation is that it's a new clinic, so that's the face, and that the core of the clinic is this cooperation between academia and civil society organizations. So before I start, I just want to say a few words about the Raoul Wallenberg Institute of Human Rights. That's where the clinic takes place. So we are a foundation and an academic institution with research and higher education. We have a master's program together with the Faculty of Law in Lund. But most of our activity is human rights implementation and development. We have offices in 7 countries in addition to Sweden. So we're not academia, but we're an academic institution, and we have close connections to the Faculty of Law, where we find our students for the legal clinic. So that relationship is also important. I also have a logo on the slide here, which just has the title, and a logo of Vinnova, which is our funder. And that's Sweden's innovation agency. So I think from that you can tell that legal clinics is not a tradition in Sweden, if you can get funding for a project through the innovation agency. So please, next slide. So I have nothing on the slide except what I'm saying, so you can listen or look at the slides so you don't miss anything by not looking at the slides. So what kind of clinic do we have then? We have a research and documentation clinic. And what that means is that students do the preparatory work for legal actions that will then be taken by civil society organization, in our case, ILI, Independent Legal Institute, ILI. And it's cooperation between academia, RWI and Lund University, and the civil society organization, ILI. So the organization gets qualified legal assistance by the students, supervised by researchers at RWI and LU. And what the students get and what we get is practical experience and the knowledge that the cases that we prefer are the ones that are needed and the ones that are important at the time. So how does it work then? ILI chooses the actual case or the legal question for the clinic to work with. And together we frame the task for the students so that it's both pedagogical and relevant to ILI's work. So it needs to be the right level of difficulty, depending on how long the clinic is, the scope of it, and so on. And the clinic, from the student's perspective, the clinic has a dual track of activities. It's supervised group work and it's academic and practical workshops. So the group work is where the students meet and investigate the case and develop the lines of argumentation. And they do that under supervision from teachers from the Faculty of Law and RWI. And sometimes also in interaction with lawyers from ELI when they need clarifications and so on. And they also have academic and practical workshops. So the academic workshops are about the areas of law where the issues they get from ELI are situated. And the practical workshops are from practical lawyers, practicing lawyers, for example, at ELI, that will talk about aspects such as strategic litigation, ethics, lawyer-client relationships. Even as an academic, I have a hard time even mentioning what these are, but the practical aspects of practicing law. And so each week they have these workshops. Next. And I think something, what this means is also that we have complementary roles at university and at RWI and at ELO and at ELI, and this is very important. So for the success of the work, it's very important how you work with those roles and respect each other's roles, but I'll get back to that later. So the work takes place at RWI, Lund University. The teachers here supervise the work and hold workshops in material law. So our main responsibility here is the focus, is the learning and the well-being of the students. So we of course have an agenda to forward human rights, but our main responsibility and focus in the clinic is the students. RWI is present to introduce the case to the students in the beginning, available throughout the clinics for questions and hold practical workshops, and is present then to receive the result of the students' work and give them feedback. So ILI's main responsibility and focus is, you can correct me later, Ulla, but it's to forward disability human rights and also to support the position of individuals through litigation. So we have common agendas, but we also have different responsibilities and agendas. Next. So before I talk more about our clinic, I wanted to say something about CLE in Sweden, that it's a recent but growing phenomenon. Like I said from the beginning, we got our funding from Vinnova. That's very telling. In 2014, the Faculty of Law in Gothenburg University started the first legal clinic in Sweden. And that was made so that students go to human rights NGOs and practice there for a while. So they give legal advice or they do other legal work in the organization. In 2016, the Faculty of Law at Uppsala University started their legal clinic, and they developed the model that we use in Lund together with a human rights NGO called Civil Rights Defenders, used to be the Helsinki Committee. And then in 2019, we started our clinic, and it's the first clinic with a disability human rights focus. And I think it's important here also to note that student organizations have organized information initiatives or advice initiatives since the 1970s. So from this, we can tell that the student interest to make a difference and to engage with practical litigation has been there for a long time, or practice of law. Next, please. So you can talk about why is this so late in Sweden? I don't have any real answers, but these are some things that I've come to my own mind and I've also heard others bring up. One is that the legal education in Sweden is a judge's education, which means that there is not so much focus on argumentation, representation, client meetings, and so on by the teachers and by the faculty. Also that there is generally little interaction between academia and practice compared internationally. And then my own favorite is that I think that there is a delusion in Sweden that all people have equal living conditions, that we don't experience human rights abuses, we all know our rights, and we have access to courts if we want to. And as long as that idea is around, then the use of legal clinic, the need for legal clinics doesn't seem very big. Also, when I've met others from legal clinicians from other countries, they've mentioned that they've mentioned things that I don't recognize in a Swedish context, which is that university studies is seen as a privilege, and so you should give back to the community. Again, don't see that here either. So to the question then, how we maximize usefulness of clinical legal education for disability human rights in Sweden, that's what we're going to discuss later. But I think by looking at the questions why it's so late in Sweden, we can also see what are the obstacles that we have to overcome in order for clinical legal education to grow in Sweden. Next, please. So how did our clinic come about then? I think what's important here to notice was that it was established on, it was due to already established relationships between academia and civil society. So RWI was asked by civil rights defenders in Uppsala University if we wanted to field test their clinic model, which they initiated in 2016. And then we consulted the Faculty of Law, who were cautiously positive. I think it's a fair way to say it. Very happy about it, but it was new. So of course there is concern for what this means for students. So RWI agreed to do this with the blessing of the Faculty of Law, because that's where we get our students, so that's important, and also our teachers. But if the focus could be disability human rights, and that was fine. And then RWI asked ELI to cooperate and provide the cases, and ELI agreed. And behind this is, of course, that I've talked to Ola and also Adolf Ratzka for a long time, have talked about the need for legal clinics in Sweden. So that was already there, sort of that relationship and that dialogue was something we already had. And the disability rights focus again then was circumstantial. It was because of the agenda and the capacity of me, basically, here at RWI and ELI. Next, please. So if you look at the form of clinic that we have, we can see that it's very close to usual academic work. And that is because of this lack of tradition. It's easier for faculties to accept that, but also organizational and administrative factors. Something that I've heard a lot is that faculties are afraid to put students in exposed situations and situations where we or them can be liable for giving wrong advice or doing something wrong. And there's also concerns about matters of secrecy and confidentiality, as all university employee correspondence are public documents. So these are also reasons why it's hard to get the clinics to be part of the curricula. Our clinic was extracurricular the first time, and now we worked our way to that the second time is going to be part of the curricula. Next, please. So the work so far, the first clinic is just about to end. The students have investigated 2 cases and produced 4 reports, which ELI are now looking at and going to provide feedback on. Case 1 was the right to assistance in the home to prevent institutionalization of children with disabilities. And the second case was protection against integrity intrusive needs assessment. And the students looked at 2 instruments, the CRPD and the ECHR. So the next step then is that ELI will use this material to take legal action, and possibly the next clinic could be the students writing a complaint based on the lines of argument in the report, possibly, we will see. And also if I rewind, I will also say that we had a very useful workshop in Lund before we started, drawing on RWI's international network. So RWI works with many partners worldwide that have a lot more experience with legal clinics. So we had the funding to bring them here to Lund, and we avoided a lot of mistakes by listening to them. So next, please. So the first time you do something, there's always challenges as well as lessons learned. The challenges was it was hard to get key actors at university to understand what the clinic was about and the point of it. And also another challenge that we had the call for participants. Not one student from the Swedish law program applied for the first clinic. So that was very discouraging. But we had loads of applications from students from the master's program that we have in international human rights law, who were more familiar with legal clinics and also more familiar with extracurricular activities, I think I dare say. Funding will be a challenge once the funding we have for the 2 clinics are finished. And a big part of the work has been to try and anchor the clinic at the Faculty of Law. And they've been very positive and helpful, and so that has worked bit by bit. Lessons learned is that it's important to set the roles and responsibilities between the civil society organization and academia, or RWI in this case, so that you know who's supposed to do what and when. But it's also important to be flexible and to have a mutual understanding and respect for the mandate of the other party, because things will happen suddenly and things will need to be changed. And if you have a good working relationship, then that makes a big difference. I've been grateful many times when this first time things have not gone the way I wanted to. And also to make sure to anchor the clinic, key actors at the university, to talk to more people rather than less, to make sure that everybody is on track. And then to understand what are the misconceptions about legal clinics in academia that make people be negative towards them, so that they can be addressed. And then I'm missing one that should be on this slide, which is to address one more I had under the lessons learned, was also that it's not only misconceptions, important to say, on behalf of academia, it's also very valid concerns, because their main focus is the students, and it should be the students. So to address those as well, not just misconceptions, but also the valid concerns, and to find solutions to these together is the point. Next, and that's the last one. So, but we still count some victories, I think, very important. 7 students are now knowledgeable and interested in disability human rights law. 4 reports are being delivered to ELI, ready for action. We cooperate with ELI in different ways now, additional ways. For example, we get topics for student papers, reality checks to guide research and teaching, and so on. So the relationship has developed in other areas important for rights of persons with disabilities as well. And the clinic is now part of the curriculum at the Faculty of Law and gives credits. So this time it's going to be a real course, which we're very pleased about. And more Swedish students than we can take in have actually applied for this second term of the legal clinic. So it proves that things can improve. And I like to think that by doing this, we're laying the ground for future introduction of multidisciplinary clinics, street law, and maybe in time even for students to work with live clients and be a part of legal action themselves. Yes, thank you very much.
Thank you, Anna. I think we have a question directed to you from Lisa Waddington here. It is about the language, and more particularly if we work in English only, or if we work in Swedish also, which means technically that if we only use one language, that we could only take a limited amount of cases or work in limited ways. What are your experience of the choice of language as a limitation?
That it's definitely important, and we've had to work around it. This first time it was international, it was students in the master's program, but there were 1 Swedish student in each group, so that we could put that task on them. But it definitely limited us when we needed to look into requirements of lawfulness and procedure, and to look into Swedish practice and Swedish law. This time we have Swedish students, so that means we're going to have less knowledge in international human rights law, because they're not on master's level, but they will all be Swedish speaking. And also there's the problem that Swedish students are less likely to sign up for courses that are in English, because they see it as harder for them to perform well and get good grades. So there's loads of different, we had to work around it this time. And if we had more Swedish speaking students, we would have been able to be more concrete in our conclusions, definitely. Yeah, but we also thought that ELI has that knowledge as well. So if we bring the international lines of argument, then they can sort of fill in the blanks more easily. But next time now we have Swedish students, so we'll see how that goes down.
It is definitely a very useful resource to cooperate with you, because we don't have the time always to dig that deep into the international law of things concerning these subject matters. So without this clinic, I don't think we would have reached as far as we can on strategic litigation, because that's what we're aiming to do. We need to have a legal analysis connected both from the international law to the Swedish law and the circumstances of a case to conduct proper strategic litigation, and not just taking a case that comes into our legal advice channels, but rather to formulate what cases we really want from a perspective that we can actually win a case or have something tried from an international law perspective. So I'm really looking forward to continuing this work from reading all these reports. And, can I ask you also, what do you see as the future of this? I know you've been working quite actively with the faculty, and you mentioned some of the struggles that you've had. What is the future now that you see?
I don't know. I'm cautiously optimistic. I think there's a big interest to give this kind of knowledge and experience to students. And as I said before, I think there's valid concern because of the main responsibility to our students. So I think it's good the way we go slow, actually. We did extracurricular the first time. Now it's going to be part of the curriculum once we run the pilot and avoid some of the mistakes we made last time. And when it comes to other kinds of clinics, I don't know. It would seem to me that street law would be more and easily acceptable than live clients. The closer it is to academic work, the easier it is to obviously, as it would be in any kind of activity. The closer it is to the core activity, the more easy it is to bring it in. So I'm positive. I definitely think it's here to stay, but the pace at which it develops is hard to, we just have to be really good and really successful, and then everybody will want it.
Perhaps that's a point where we can discuss after the individual talks regarding how you establish such an initiative, especially long term.
Yeah.
Okay, next up we have Jose Martochi. I think we're going to do the break after your speech. Welcome.
Buenos días. Espero que estén muy bien. Estoy muy agradecido de la invitación. Estoy hablando desde el sur del sur, desde la ciudad de La Plata, muy cercana a la ciudad de Buenos Aires, en la Argentina. Soy director de la Clínica Jurídica en Derechos Humanos y Discapacidad de la Universidad Nacional de La Plata.
Hello.
Mi nombre como...
Thank you all for inviting me here. I'm speaking from the south of the south. We have the clinic in the city of La Plata, which is near Buenos Aires city in Argentina, and I am the director of the legal clinic of the University of La Plata in Buenos Aires, Argentina.
La universidad donde yo trabajo es una universidad pública sostenida por la comunidad, por los impuestos de la comunidad, y es una universidad pública que, en consecuencia, tiene una función no solo docente y científica, sino también de extensión a la comunidad. Esto significa que
Yes.
lo que...
The university which I work, where I work in, is a public university supported by taxes paid by citizens. So the university has a learning mission, but also a social mission that is provided through some sector of the university to give services to the community.
El programa de clínicas jurídicas de la Facultad de Derecho en la que trabajo es un programa que funciona en el área de extensión de la facultad y que fue creado hace unos 15 años y que desde ese momento se desarrolla de manera sostenida, creciente con participación de estudiantes y de graduados muy jóvenes.
The program, the Legal Clinic program, where Jose is, where I am working, is working since 15 years so far, and it works with the collaboration between students and young early graduates, and coordinated by law professors.
Como les digo, nuestro trabajo está ligado a la comunidad y en particular, en relación con la discapacidad, está ligado, trabajamos a la luz de la Convención Internacional sobre los Derechos de las Personas con Discapacidad, que en nuestro país tiene rango constitucional desde el año 2014.
They use the CRPD as the main tool of work within the Disability Law Clinic, the convention, the CRPD convention, is it has high constitutional higher. I don't know how to say that, but it has the same. It is at the same legal level of the Constitution, so it is an internal instrument of law.
Al tener rango constitucional, la Convención es una norma fundamental que debe regir por sobre cualquier norma interna de nuestro país. De manera...
Yes.
Sí.
Hierarchy was the word that I was trying to find. So as it has a constitutional hierarchy, it has the power of the same level of the Constitution. So every law within the state, at the national level and at the state level, has to comply to comply with the standards of the convention.
La clínica jurídica en discapacidad es un espacio autónomo en relación con la clínica jurídica en derechos humanos. La clínica en discapacidad tiene un desarrollo cercano a los 10 años, inspirada en la Convención, y trabajamos representando a la comunidad, a grupos específicos y a asociaciones de la sociedad civil.
They work representing civil society organizations, people with disabilities, before courts since 10 years old, specifically the Disability Rights Clinic.
Nuestro trabajo se enfrenta a dificultades porque nosotros esgrimimos el modelo convencional, que es un modelo social de la discapacidad, frente a normas y prácticas sociales e institucionales que se rigen por un modelo médico que la Convención precisamente viene a derogar.
The main challenges that they face when they represent clients at courts or in administrative claims is that they have to implement the standards of the CRPD in a system that is ruled by the standards of the medical model that has not yet approached or arrived to the standards of the CRPD.
Todas las problemáticas que llegan a la clínica obedecen a que nos enfrentamos a un modelo médico que aún no es permeable al modelo social de la Convención.
All the issues that they receive have to be with the same issue. The cases, the violations that the clients suffer can be explained that this, but the fact that the legal the law framework of the state is not yet has not yet achieved the standards of the convention.
Los temas son variados, de temas ligados a problemáticas sociales, como por ejemplo vivienda para personas con discapacidad, o viviendas para niños con discapacidad que no pueden ser externados de los hospitales, y también temas de tipo estructural, donde hemos llevado adelante casos que han cobrado alta resonancia social e institucional.
They have a great variety of cases, like individual cases. For example, they have represented children whose families cannot afford a house, an adequate house for them to live in, because they need the house to have some properties, some accommodations that they could not afford. So those children were still living in hospitals and health institutions. So they represented these kind of individual cases, asking the state for actually a house for their parents and the children, but also collective cases of high public profile.
Respecto a los casos relevantes, hoy me voy a referir en particular a uno vinculado al artículo 19 de la Convención, que es el artículo que consagra el derecho a la vida independiente.
One of these cases of high profile or public interest law cases was one related to Article 19 of the Convention, which is the one that states the right to live independently.
El caso se origina en que el Estado de la provincia de Buenos Aires, donde vivimos, no reconoce la figura de la asistencia personal para la vida independiente, que es un apoyo específico, concreto, que la Convención consagra para justamente atravesar las barreras que se oponen a toda persona con discapacidad para acceder a una vida autónoma, independiente, libre.
The collective case that he wants to talk about today is the case that was originated in the fact that the state of Buenos Aires, the province of Buenos Aires, its health insurance institute, its health institute, the public one, does not recognize personal assistance as a health benefit within this institution. So citizens with disabilities in the province of Buenos Aires cannot access personal assistance. They can access to other health benefits similar or that can be related to that, but not this specific benefit. So they cannot obviously access to all the rights that come with it, specifically the right to live independently.
Ustedes saben que la figura de la asistencia personal es una figura que ancla en el modelo social. El Estado de la provincia de Buenos Aires no reconoce la figura de la asistencia personal, tampoco la aplica, sino que ofrece otras figuras, todas vinculadas al modelo médico. Es decir,
instead of the personal assistance, they offer the state, the health institute of the state, offers other benefits related to the medical assistance of the person, but not the personal assistance in the terms of the convention.
La postura del Estado provincial fue justamente ofrecer figuras vinculadas al modelo médico, y nuestro reclamo es que el Estado provincial incorpore la figura de la asistencia personal, entendiendo que la figura de la asistencia personal es una figura clave para consagrar, hacer posible, hacer efectivo el derecho a la vida independiente de personas con discapacidad.
So although the state was insisting in the fact that they were providing this benefit through other medical benefits, their claim, their judicial argument was that those benefits were not aligned with the right to living independently, so the Health Institute would have to modify, to adopt other benefits, like the personal assistant to comply with the convention.
Al no recibir respuesta por parte del Estado, debimos impulsar una acción colectiva. Come on.
They took a class action, a collective case against the state of the province of Buenos Aires and its health institute, representing all people with disabilities in the state.
El argumento sencillo fue que la convención es un instrumento que obliga al Estado y que el artículo 19 de la convención obliga al Estado a implementar la figura de la asistencia personal para la vida independiente.
They argued that simply that the state has a conventional obligation to incorporate the figure of personal assistance as one of their health benefits within the Health Institute of the state of Buenos Aires.
El argumento del Estado fue que no está obligado a incorporar la figura de la asistencia personal y que si estuviese obligado ya tiene figuras para ofrecer, apoyos para ofrecer a la persona con discapacidad.
The state denied that it is obliged by the convention, and they say that with the other benefits that its health institute provides, people with disability can have quotation marks personal assistance, but obviously from a medical perspective and not in the terms of the personal assistance. José, tenemos 5 minutes.
Sí, 5 minutes.
Okay.
Lo interesante de este proceso no solamente es la colisión entre el modelo médico y el modelo social convencional, sino también que fue un proceso donde se consagró el derecho a la participación comunitaria. La jueza a cargo del proceso abrió el proceso a la intervención, no solo de amicus curiae, sino también de sociedades vinculadas a la militancia por los derechos de las personas con discapacidad.
So the interesting thing of this litigation, of this judicial procedure, was not only the fact that there was a collision between the conventional standards and the legal state and national framework, law framework, but also that through this class action, the main client, which was Asociación Azul, a DPO, asked for a public hearing. They asked the judge to order a public hearing, so all the community, including experts in the disability rights field and also the other DPOs in the state of Buenos Aires, could join and make arguments about the action and what they wanted the judge to decide.
Las partes y la jueza pudieron escuchar a expertos hablar de la figura de la asistencia personal y de la importancia que esta figura tiene para la vida independiente de personas con discapacidad. De modo que la jueza, luego de escuchar expertos y luego de inspirarse, fundarse en las observaciones generales del comité de la convención, hizo lugar a la demanda y obligó al Estado de la provincia de Buenos Aires a consagrar la figura de la asistencia personal.
So the judge accepted this request, and she actually heard the voice of experts, and this, I'm adding this, Jose, the names of Facundo Chavez Penillas and the special relator, the special rapporteurship, Catalina de Bandas, and she inspired her decision in the voice of these experts and also in the general comments of the CRPD committee. And she actually decided in favor of the law clinic claim. She decided to order the state to provide specifically the figure of the personal assistance within the health benefits that they already provide, but not in the way they wanted to do it, but in a new way that they have now to plan and design in the terms of the convention.
Para concluir, vemos cómo un proceso es una herramienta eficaz para impulsar al Estado a llevar adelante políticas públicas generales, colectivas, vinculadas a tratados de derechos humanos que el propio país incorporó a su normatividad. La jueza ordena llevar adelante una política pública ligada a la figura de la asistencia personal. Este es el gran logro del proceso.
So in conclusion, with this example of collective action that the law clinic took to the court, we can see that the judicial procedures, taking these cases to court, is an efficient tool to make the state comply with the international law that the state actually incorporated to the internal law, but still is not in the internal law. It still is not a reality in the internal procedures, in the benefits, concrete benefits that the Health Institute is providing. So litigation, taking cases to court like these, collective actions, is an efficient tool to make the states to comply with the convention. And that's it, I think. Eso es todo, José, ¿no?
Y ya para despedirme, última cosa, también para destacar es que la jueza ordena llevar adelante la política pública con participación del colectivo de personas con discapacidad en el diseño y redacción de la resolución general que adopte la figura de la asistencia personal.
Y con eso cerramos.
Sí.
Yes, and the last thing that it's important to mention is that also the judge not only ordered the state to recognize the figure of personal assistance, but also she ordered the state to design this policy with participation of people with disabilities and their organizations. She ordered the state to make this process participatory. And that's it. He thanks all of you and is open to questions.
Thank you very much. I would like to ask you something before we take a break briefly. Now, I understand that the CRPD has a very high legal standing in the Argentinian legal system. Do you think that this would have been a successful case if it wasn't? And also, do people in general know their rights because of the hierarchy positioning that the convention has?
Dos preguntas, José. La primera es que si vos pensás si este caso hubiera sido viable o si hubiera tenido el mismo resultado si la convención no tuviera jerarquía constitucional, por un lado. Y por otro lado, si debido a esta jerarquía constitucional la gente conoce sus derechos o no.
A mi juicio, este caso no hubiese resultado favorable si no estuviésemos viviendo en la Argentina en un paradigma constitucional de derechos humanos, donde la Constitución es una carta máxima de derechos humanos, que obliga a las autoridades y obliga a conformar las leyes y las prácticas institucionales al paradigma de derechos humanos.
He believes that the case would not have been the same if the CRPD convention, if the Convention of the Rights of Persons with Disabilities would not have a constitutional hierarchy, and also if the constitution itself would not have, as it has, a lot of international human rights treaties incorporated in the Constitution. He thinks that it would not have been the same.
Y la segunda pregunta.
Sí, and the second question?
The second question. La segunda pregunta es muy profunda y interroga acerca de la efectividad de los derechos o de cómo llevarlos adelante. Y yo entiendo que no solamente se trata de conocerlos, sino también de que el Estado y la sociedad encuentre herramientas para impulsarlos, para reclamarlos ante los tribunales, que haya defensores públicos, que haya operadores jurídicos en condiciones de impulsar estos derechos, porque si esas herramientas no están, los derechos quedan en la letra.
About the other question, he thinks that it's a very deep question, but he wants to say that he thinks that it's not enough to have rights recognized in our legal instruments, even if that instrument is the Constitution, but instead we need to have defenders and actual people who take these cases who give these cases and these rights teeth. And make these cases and take these cases to court, make legal claims. Without these teeth, these rights have are no real.
Thank you very much, Jose, for your answers. I think we're going to take a 3-minute break just to clear our minds a little bit, maybe get some coffee, and I'll see you back at 1:45. I hope everybody is back. And with that, I would like to invite Juan Cobeñas to speak. You're very welcome.
Hello, all. Can you listen? Can you listen?
We can hear you.
All right. I am Juan Cobeñas. I belong to an organization in La Plata, Argentina. We have been working on personal assistance and independent living for more than 10 years. I think that working with the legal clinic is one of the legs that support our advocacy strategies. We we work with Dr. Martocci's clinic with total communication. They ask us about all the ideas they have, and they defend our principles and our ideas, and they defend our principles and our ideas and desires. They work understanding thoroughly the principles of the convention, and we do not have differences of philosophy with them. They do not tell us what to do, but they teach us the strategies they use as lawyers. They help us not only at court, but to write notes to the government, to order the actions, advocacy actions, and then also in litigation. We trust them completely. We advocate for personal assistance because in our situation in Latin America and Argentina, we know that this is the main support we need to live independently, to start to think on independent living. We also sent a project of law to the Parliament of Buenos Aires province. The project was approved by 2 commissions at the parliament, but then lost the parliamentary status because of political issues, general issues, not because of the project itself. We are now waiting that this judgment that orders the state to provide properly the service of PAs is secured. The judge listened to many of us at court, and she saw us with our personal assistants there. She saw personal assistance in action. She saw what we needed in action. The legal clinic prepared us to go to the hearings, and we helped with our connections as Catalina de Bandas and Facundo Chavez, so that the judge could listen to relevant positions about support and personal assistance in particular. We think that the legal clinics needs to have support to work more and serve to more people and organizations. This is all I had to share with you. Please ask me questions if you like.
Thank you very much, Juan. I have a question to you. Seeing as you are an activist and work with political work in different ways, trying to change the system and implement personal assistance in your community, how would you see that it is best done from your point of view in relation to a law clinic? What is required for successful litigation in the end, if the law clinic is there, but what do you have to do as an organization to do this all the way to be successful?
I am talking in English, finally. I did not need translation. I wanted to tell you this. About your question, you need to be very active to talk to the people in government in different places. They need to see directly the people with disabilities in charge of the advocacy. We need to show that the model of human rights is completely different from all they have seen before, that we are in charge. No parents, no lawyers, no doctors. The leadership is ours, and they need to see this in action.
Thank you. It seems like a very important comment that when you do strategic litigation like this, there shouldn't be any other interests than those of the DPO and the people behind it. So that, for example, the lawyers don't take over and have some other interests at stake through this, but that you make sure somehow that the DPOs are in control really of the subject matter. Thank you for that illuminating answer. I think we should then move on to the final stage of this webinar. We have a few Q&As, I think. Would you like me to go through them, or have you already done it behind the scenes here? From Enil or Ili?
I think, Ola, there have been, this is Ines speaking from Enil. There have been a couple of questions that were answered in writing by Anna and Michael, but the questions that you see as open questions are still haven't been answered. So if you want, we can go through those.
Yes, I think that's a good idea. If we go from the top.
Yes. So the first question is to all the panelists. Sorry about that. How do you ensure that the work of the students is actually effective and helpful to the petitioners, especially concerning the time lag, because the students need some time for working and their work needs to be supervised, and the uncertainty of court's decision making? I don't know, this, you can assign this to somebody, I think, Ola. Perhaps Anna could take this.
Yes, I would like everybody who's in the panel that has been speaking, if you have anything to add here. I see also that Jose, you're still here, so please, both of you, who wants to go first?
I can go first.
Yeah.
And I think you can answer this probably better than me, Ola, so maybe together we can answer it. I think in our case, it's how do we make sure it's effective for Ili? Well, first of all, the initial issue comes from Ili, so we know it's relevant. And then we work closely together to make sure that it stays relevant. And as soon as there's a there's a path choice or something about what to investigate or what way to run the argument, then we have a dialogue. And then also the sequence of this strategic litigation, which is that Ely sees, if I am correct, then Ely sees many cases with a serious problem, and they describe the case as specific as possible to us, but without it being about a particular person. And then after we submit the analysis, a particular case is created, so that's how the timing is not a problem, and that's how we keep the relevance. And court decisions, I think, well, that's also for you to answer, Ola, but I think that of course, for the individual, you always want the positive decision, but in order to bring it back to policy making and law changes, we also need the negative decisions so that we can start lobbying for a change of laws if they don't reach. And also to get to the international level, we need to go through all the domestic levels first, even if we know that we're probably not going to get the positive answer. Yeah.
Yeah, I think you're right in that. That's the way we've done it in this clinic, that we have not tied it very closely to a person to begin with. First of all, that was partly because it's sometimes hard for people to step forward when it comes to issues that are quite integrity close, or even by definition violating of the person's integrity. So that's something that we need to work on longer term. We've identified some issues that we went with in this law clinic, and that's also something that I guess is a very important discussion to have when you establish a clinic. And I'm thinking about what you said earlier, Juan, also, that the DPO should be in control, that you have to, as a lawyer, if you get a case on your table, you need to go through what is practically possible and not. You have to talk about the risks and how long everything takes. So you need to be transparent with these things. So I think your example that you showed us on personal assistance in Argentina shows that you had a pressing issue. You used the clinic as a tool to advance the position regarding the CRPD Article 19 and personal assistance in particular. But I suppose maybe I should ask you this. Did you have such a discussion with the lawyers and the students at the clinic, or how did that work from your experience, Juan?
We took the issue to the clinic some years ago, and we described the obstacles we saw. Anyway, we have a good knowledge about the convention. So we knew what we wanted to achieve. We knew how the personal assistance service should work, and we knew about our system of services for persons with disabilities. So we took all this to the legal clinic. We had many meetings, and we had to learn more For example, I was in Geneva for the debate day on Article 19, and we learned from general comment number 5, and we need to be informed, but always in contact. They listen to us at the clinic. They ask us about things that have to do with personal assistance itself. Yes.
Yes, thank you. I think we have that question answered, and we should move on to the next. Here we have a question for Jose. It's about Brazil and international human rights conventions, where they also have the hierarchy as, or the same hierarchy as the constitution, and the judges are hesitant to base their decisions on international conventions. And the question is that that Barbara wants to know if it's the same in Argentina, or if judges are more willing to quote and base their decisions in international documents.
José, la pregunta desde Brasil que te pasé.
En la experiencia de litigio en derechos humanos en la Argentina, es muy común, absolutamente común, la cita no solo de normas de tratados internacionales, sino también de decisiones de la Corte Interamericana, observaciones generales de Comité de Naciones Unidas, y es muy común que los jueces funden sus decisiones en los tratados de derechos humanos. La letra de nuestro derecho público es la letra de los derechos humanos.
Yes, in Argentina, in human rights litigation, it's very common to find decisions, judicial decisions that quote human rights treaties, and not only human rights treaties, but also general comments from the UN committees and from recommendations from the Inter-American Commission for Human Rights. I would add something. José, estoy agregando una cosita. The jurisprudence of the court, the jurisprudence of the Supreme Court of Argentina is that our law must be interpreted in line with the interpretation that the human rights treaty bodies have given to those treaties. So unless that jurisprudence change now, our judges have not only the treaties themselves, but also the jurisprudence of the committees to take that as the official, let's say, interpretation of the treaty, and use that arguments in their decisions. That's the answer.
Thank you. Then we have another question here from Ritu Mekonen about children with disability or intellectual disabilities and access to education. Well, it's not really a question, it's more of a comment, I think, stating that they don't have education aids or curricula. I don't know if you have in the panel any experience of clinic work connected to education and the rights of children with intellectual disabilities.
if nobody has, I think that we can share something. I mean, José. José, la pregunta es si... Es una pregunta a todos los paneles. Ofrecí que por ahí nosotros podíamos decir algo. ¿Cómo los niños con discapacidad pueden acceder a la educación alrededor del mundo? Esta pregunta viene desde Etiopía, pero quizás nosotros podemos dar las experiencias de Argentina, porque allá no tienen asistencia para la escuela, ni currícula adecuada. Un comentario por ahí podemos hacer.
Un comentario breve. Muchos de los requerimientos de intervención de la clínica tienen que ver con la educación inclusiva, que está consagrado en el artículo 24 de la Convención, tanto en el aspecto del ingreso al sistema educativo común, como de la permanencia, o como de la titulación. En los tres planos hemos litigado, y particularmente ligado a la titulación, hemos obtenido también una decisión judicial muy importante que ha eliminado la discriminación en el título en relación con personas con discapacidad, jóvenes con discapacidad.
The legal clinic, the law clinic in Argentina had cases about inclusive education. And they have litigated cases to access to education, to access to regular schools, because we still have in Argentina a segregated system of special school and regular schools. So they had cases to guarantee the access to regular schools for students with disabilities, also to guarantee the rights during the time that the students is in the school throughout the whole trajectory, to make adaptations, adequations, reasonable accommodations. And also, finally, the more significant case was one that eliminated the discrimination between the certification, the title, the diploma that the students with disabilities received before the case was different. The diploma and the certification that the students without disabilities receive when finalizing regular high school. So they took a case to the court that eliminated this distinction, and now in that case the students with disabilities received a diploma, the same diploma that students without disabilities have.
Yes, thank you. We have a comment here also from Paul Lapalainen. It's about access to justice. Perhaps we should invite you to say something about this in your experience also. Are you with us still, I hope? I've enabled your microphone, I hope.
Can you hear me?
Yes.
Well, one thing I was thinking about in regards to what Michael was saying is that at least in the US, and I realize there are not enough disability law clinics and not enough public interest law firms working with disability issues, but I do think they've made major inroads in regards to providing at least some access to justice in regards to concrete, say, daily legal issues, but also in regards to a lot of precedents and case law that's been set that's been important in other contexts. I was just thinking about, I'm not sure that law clinics were involved, but some of the first cases establishing the right of disabled students, disabled people to an education, or young people in the US, the right to an education, took place during the 1970s. They were definitely, at least they were brought by people who had non-monetary motives. They thought that their children had a right to establish, or should have a right to an education. They were being denied a right to an education. And these cases were eventually developed on the basis of constitutional law. So again, at least my comments related to the idea of law clinics eventually contributing at least to the idea of access to justice, which can be limited, at least from what I see in Europe and from what I see in Sweden. If the Equality Ombudsman refuses to help somebody, then most people who have disability discrimination cases are going to have a tough time taking cases. And it's hopeful with what Anna Bruce is saying about the situation or the clinic in Lund. But it seems like much more could be done in this regard. But it's great to hear about the cooperation between civil society and the law school. So that's what I was thinking about.
Yes, thank you. I think this is an important thing to stress, that they are actually providing access to justice for individuals if they're done in the right way. That's the purpose, not just educating the students, but actually providing legal aid or access to justice for those seeking the support. I have one final comment here again from Brito. I don't know if you're still with us, if you would like to say something, or if I should read your comment. Do you have a question to the panelists? It's about how to address legal clinics beyond the university, and that there is a lot of work to be done still with the rights under the CRPD. I'm not sure whether you're with us still.
I'm sorry, for who is the question? For Jose?
No, it's for one of the participants that asked a question or put a comment here, but I can't.
I don't think he or she is here anymore. Ola.
Okay. That means we can go on to, I suppose, the final words for the panelists. I think so far we've had a very illuminating discussion on various aspects of law clinics and how they can work to strengthen the right to access to justice and the right under the convention in different ways. So I would invite you to, in 1 or 2 minutes, to say something final, what you think the future should be in regards to law clinics and the promotion and protection, especially protection. I don't like the word promotion of human rights for persons with disabilities. Should we start with you, Anna?
Okay, well, first of all, I'm just since we're rookies here in Sweden and in Lund, just beginners, I'm very inspired by the what the other panelists have told me about their work and their successes. So that's my main impression. When it comes to how to move forward in Sweden, I think it's just these little steps at a time. Like, all I know about is the university side, how to anchor it there and to make it work. I think what would be really important in relation to access to justice generally and is to make a needs analysis of Sweden in terms of legal clinics. Where are the gaps? What are the groups beyond persons with disabilities, disabled people? What issues? Is it strategic litigation? Is it access to justice for individuals? A lot of cases. Where are the needs? In this case, we started and we did not make a needs analysis like that. We decided disability issues, and Ely made the needs analysis in terms of what issues to have. But I think a larger debate or analysis on the role of legal clinics in Sweden, taking into account both the organizational and the administrative constraints of universities and how we can get over those. but also this the social justice purpose that it's supposed to fulfill, like a needs analysis for how clinics have to be, what kind of clinics would fill those needs. Yeah.
Thank you, Anna. I would invite, I see a message here from Juan also. Welcome to share your final thoughts on this seminar. And after that, we move on to Jose and Mariela.
I wanted to answer the lady from Ethiopia that the cases mentioned by Jose were about intellectual disabilities. As for my final thoughts, I wish that countries like mine have that countries like mine have a greater development of legal clinics, that they can involve more interested students and mentors, but that they don't forget to make connection with activists. If they grow, they may forget what is the protagonist, who are the protagonists of the story. Do not forget that. Thank you. I am very thankful for being with you this morning. Thank you.
Thank you. And are you ready to say something on the future of the law clinics, Jose? Welcome.
Unas palabras finales sobre el futuro de las clínicas jurídicas como instrumento de protección o de acceso a la justicia para las personas con discapacidad.
Los derechos humanos y los derechos en general son productos de conquistas sociales y políticas que cristalizan en convenciones y en tratados, pero esto no nos salva, no nos exime de tener que volver a militar los derechos, volver a accionar los derechos. Como decía Juan, el sujeto es protagonista de su propia historia y es el sujeto el que tiene que impulsar los derechos que le faltan a su vida. Las clínicas, los operadores, las facultades de derecho, el Poder Judicial debe estar a tono con estas luchas.
Yes, so human rights are the results of political and social fights and fights. So he is saying that human rights demand constant action and constant activism from human rights holders, and law clinics, law schools and universities, and even the judiciary have to be prepared to this demand to make human rights a reality, because although we have the treaties, we cannot, as Juan said, we cannot leave aside social and political work and strategies.
Thank you very much, everybody. I think this sums together the discussions we've had, that law clinics are a tool for access to justice, law implementation, human rights implementation, and that it's important to include and not take any other interests at the steering wheel from the people that have the rights. And this is where I think we should move on with having this confirmed, that it's important to have DPOs in especially this field to decide the priorities and to move ahead with law clinics from that point of view. So I think we're about to end this webinar right now, and I would like to thank Enil again and the Disability Rights Defenders for organizing this webinar. There is a link here that includes an evaluation form, which I know that the organizers will be very happy if everybody fills in. This recording will be available on YouTube and in the Facebook group, I think, within a week or so. Sometime after this, it will be texted. So if you haven't already, please join the Facebook group, Disability Rights Defenders, the Law as a Tool, and subscribe to the newsletter. Thank you very much for letting me be a part of this and taking you through this very interesting set of speeches and discussions.
Thank you, everyone.
Thank you.
Goodbye. Close the webinar.
Thank you.
Thank you.